Next week, the Southern District of Illinois is going to be hearing the Federal Firearms Licensees of Illinois case challenging the January 1st deadline to register semi-automatic firearms in the state of Illinois. Look at the calendar. What's today? The 8th of December? We've got less than 3 weeks now before that deadline. And this all stems from the Protecting Illinois Communities Act enacted January 10th. And how all that happened, we'll probably have to put together a review of sorts, especially heading to the end of the year, looking back over the past year and all that's transpired. So I will bring that detailed breakdown documentary to you before the end of the year so we can get a general idea of how far we've come, step by step, since even before 2022 was over. So welcome in, Bishop on Air. Thanks for hanging out. Like, subscribe, follow along, get those updates, hit the notification bell. Support the program if you want. There's some merchandise below you can check out on the YouTube channel, or you can go to bishoponair.com. All right, so December 12th, big things happening. That's Tuesday. You've got the Joint Committee on Administrative Rules, a legislative body in Illinois that oversees administrative rulemaking with the state police, for instance. Also, December 12th, you've got the Southern District of Illinois court's going to hear oral arguments in a case challenging Illinois' gun and magazine ban registry. So all this happening next week, and what we've got is the legislative body that's going to review the most recent rules that Illinois State Police issued concerning the gun registry. So that's going to happen. Whether or not they move to suspend those rules, it's anyone's guess. It's a bipartisan committee, but they would need somebody from the Democrat side to go along with the Republicans in order to suspend those rules. So that's not guaranteed. They could object to the rules, but that's not going to suspend them. That would just be a red flag to any court. And then you've also got the opportunity for them to provide some suggestions, which they did a couple of months ago, where they told Illinois State Police they had to have 3 public hearings on those rules. So while that goes on December 12th, next Tuesday, with the Joint Committee on Administrative Rules that morning, in the afternoon, Judge Stephen McGlynn's going to be hearing the Federal Firearms Licensees of Illinois and other plaintiffs, including Guns Save Lives and others. They're all going to be in court virtually to have oral arguments on the case concerning whether or not that January 1st deadline, based off those rules from Illinois State Police and based off of the Protecting Illinois Communities Act, the law that was put into effect January 10th, banning certain semi-automatic firearms, whether or not to suspend that deadline, that's the question. So I talked with Kostas Moros. He is an attorney with Michel and Associates, and he's defending, he's representing the plaintiffs in this case. And we talked about where we're at in this process and just exactly how this is going to ultimately play out in the courts. So he gives us a bit of a status update on where we're at. And make sure this audio is cranked up, because I know sometimes it's difficult to hear the audio. So just to ensure that we're good to go, check 1, check 2, and crank this channel up, and let's rock.
So all of this concerns the deadline to register. And we responded to the state's various arguments. The state submitted a 45-page, I think it was, brief in opposition, which was more than twice as long as our opening brief. And I think we responded with 18 pages last night. And the 3 arguments we addressed were their notice argument, their vagueness argument in response to ours, and finally the Second Amendment argument. And that last one is tricky, of course, because of the Seventh Circuit ruling. So we're essentially, more or less using the Second Amendment argument to be preserved on appeal in case the Seventh Circuit ruling, which we think is terrible, is reversed either en banc or by the Supreme Court, or if it's vacated or stayed by either of those 2 courts.
So again, talking with Kostas yesterday, he was reacting to them filing a response to the states, which filed something on December 1st, so last week. They filed in the Southern District saying that the plaintiffs in this case have it all wrong. Let's go ahead and take a look at some of that arguments where they say plaintiffs' arguments about the Act's timeline for implementation, similar baseless, they say, in considering whether a statutory grace period provides an adequate opportunity for citizens to become familiar with the new law. Federal courts show the greatest deference to the judgment of the state legislatures. They will not displace hastily the judgment of the legislature and conclude a legitimate exercise of state legislative power is invalid because citizens might not have been aware of the requirement of the law. Here, the legislature provided more than enough time. The challenged law was enacted January 10th. And again, this is the state's filing. They say almost a year before the deadline to submit endorsement affidavits by January 1st. And while plaintiffs complain, the state says that ISP did not issue its rules implementing the enforcement affidavit process until September 15th, they concede those rules largely just restates the statutory provisions. The state's filing goes on to say both the deadline for the scope and the endorsement affidavit process have been apparent on the face of the act since it took effect nearly a year ago for exceeding what due process requires. Plaintiffs' last-ditch attempt, they argue, is to argue that the state has retroactively criminalized conduct that was lawful at the time that it was performed. It is a misinterpretation of the act, the state says. If that were true, plaintiffs ought to have brought an ex post facto claim. They didn't, the state says, because that is not what the act does. The act has only prospective effect, the state argues. Conduct occurring before the act's effective date, January 10th, has not been criminalized. Individuals who lawfully acquire and possess assault weapons, this is the state's language, before the dates can continue to possess them. These individuals have a choice to make, the state says. They can submit an endorsement affidavit prior to January 1st, 2024 that allows them to keep possessing these weapons in 2024 and beyond, or they can relinquish possession through selling the weapon, transferring them out of Illinois, or otherwise lawfully disposing of them. What plaintiffs misleadingly label a retroactive registration requirement is, in fact, a voluntary benefit with only prospective application. So again, the state goes on to make their claim. They say the endorsement affidavit process has a plainly rational purpose. This is interesting. The state says the purpose, and plaintiffs do not even attempt to suggest otherwise. The process, they say, enables law enforcement to distinguish assault weapons that may be lawfully possessed from those that may not. So that's the rationale they give. And getting a reaction from Kostas about, hey, you guys argue proper notification wasn't issued. The state police says, hey, they passed the law almost a year ago. The rules were published September 15th. And, they don't really, go into necessarily the details of even the rules being changed after they filed this on December 1st in the courts, because state police second notice came, Tuesday? Late Tuesday? So those second notice rules are what's in front of JCAR December 12th. But again, also on December 12th, while JCAR is dealing with that in the afternoon, the Southern District of Illinois courts is going to hear a motion for a preliminary injunction to delay that January 1st deadline. Kostas' reaction to the idea that state police have given ample notification, despite nobody, and again, I'll ask the audience watching live, if you received a letter by mail from Illinois State Police with a detail about what needs to be registered and how to go through registering that? What about the detail of if you don't have the computer and you don't use the internet? Are you going to have to show up to a kiosk? And what's the process there? State Police said don't bring your weapons or your attachments to the kiosk. But how's that going to work if you don't have an email address? Regardless, Kostas, he reacts to the idea that state police have given ample notification. And let's go. Where are we at?
That once, so that's the state's argument is that once something's published, that puts everyone on notice. Once there's a new law or rule that's published, that's sufficient. And there is some case law for that. To be sure, I'm not going to beat around the bush there. There is some case law saying that, and it's a bit of a legal fiction. Government has some of these legal fictions where they say they imagine all these people are just there waiting to see new regulations. It's nonsense. It's not real, but that is the legal fiction. However, our argument in response to that is, even now, the ISP is still tweaking their rules. Their FAQ changes almost daily. We submitted evidence showing the 6-page chart they have tracking just the edits on their FAQ page. And then, the FAQ, of course, doesn't carry the force of law or rules anyway. And because of that, they've submitted 2 sets of revisions to their emergency rules to be considered at the December 12th JCAR meeting. And we don't know yet if JCAR is going to approve those. Last time the vote was 5-5. Now, do I expect that vote will hold? Probably, but it wouldn't be insane if one of those people flipped and said no, and then we'll be thrown into chaos. If JCAR rejects the proposed revisions, then we're stuck with the emergency rules, which have all the confusing problems that even ISP admits are confusing. That's why they're revising them. But even assuming it all goes smoothly and JCAR approves the new rules on December 12th, that leaves people just a couple of weeks to register during the holiday season. That's unprecedented, we think, in terms of, you can say that rules being published as sufficient notice, but typically people have months or years before things take effect. Now they have days, so we're hopeful the judge will see it our way. And what we're asking for in this motion is you can leave, the state can leave registration open if it wants. If people want to continue submitting affidavits, we have no problem with that. We just don't want the deadline to be enforced until sometime after this litigation has concluded, or at minimum, at least until people have received sufficient notice. And to your point, the state has the FOID data for everyone. Yes, maybe some people change addresses, but if they did a letter, they could get a massive amount of notice out to people. I don't know why they haven't sent everyone a letter about this to give them sufficient notice. They should.
So again, Kostas Moros with Michel and Associates, chatted with him yesterday via Zoom. A little bit of a lag in the video chat, but regardless, he was still able to give succinctly what they're looking for and how they're going to ultimately, proceed December 12th. What they could possibly see happen from federal judge Stephen McGlynn, who issued an injunction previously in the Southern District on Second Amendment grounds. But this isn't about the Second Amendment. Even Judge Stephen McGlynn acknowledged this at a recent status hearing, saying that the appeals court has the Second Amendment question. That's about a gun ban. What they're dealing with now in the Southern District is about a gun registry. Here's Kostas.
Yeah, so of course, we're big fans of Judge McGlynn. We think he reached the right ruling on the core case back in the spring. That said, I'm not going to predict what he's going to do, especially when there is that Seventh Circuit ruling he's bound by, and there are, of course, the notice and vagueness issues, which we haven't been before him on notice and vagueness really before. We've been before him on the Second Amendment. So we'll see if he agrees with us on our notice and vagueness arguments. As to the Second Amendment argument, technically no mandate has issued yet from the appeals court. So until a mandate has issued, he's not technically bound, I don't think, but I really don't see him, say ruling on a technicality that, I can rule on the Second Amendment because no mandate has issued yet. I think he's going to, I don't want to say contingent ruling, but I think he wants to hear about the Second Amendment stuff. He made that clear at our status conference a week and a half ago when the state asked if they even need to argue the Second Amendment stuff, and he said that they should. But we don't know yet what he's going to do. Now, if he does rule for us, as we hope, that would mean he enjoins the registration deadline, and then I'm sure the state will immediately appeal, and we'll see what happens. Maybe the Seventh Circuit will rapidly stay our win and registration will continue to be in force. I hope that's not what happens, and we would very strongly oppose that, because all we're trying to do here is preserve the status quo for longer so people can have more time to figure this out, so the litigation can play out and we see if registration is even constitutional, because if the core ban is unconstitutional, that would put registration into question. So I don't think this, unlike our previous motion where we're fighting over, these so-called assault weapons, our ask here is much smaller. And what the Seventh Circuit didn't really, they spent maybe a paragraph on registration, and the issue there was they talked about this as items that are not protected by the Constitution, because they're talking about the AR-15, and they decided that's not protected. But this covers more than just rifles. It covers handguns, it covers shotguns, it covers parts, it covers certain ammunition. So we hope that if Judge McGlynn does rule our way, that the Seventh Circuit does not stay his ruling and just lets registration, the deadline, be enjoined for the time being. And we think that would be helpful to everyone, because it would ease confusion and it would give time for the court cases to play out. And at the end of the day, if we lose, we hope we don't think we will, but if we lose and the state's assault weapons ban is upheld, registration can go in force. There's as long as it's not vague, as long as people know what to register. So I think it's in the interest of the state as well to avoid this chaos, because if the registration deadline happens and then later the ban is struck down, then there's real troubles.
So again, that's Kostas Moros, and I think Todd Vandermeide in the comments correcting me on the pronunciation of the law firm that Kostas works for. It's Michel and Associates, not Mitchell and Associates. If that's right, Todd, give me a thumbs up. So yeah, I appreciate you getting that correction in there. So again, December 12th is going to be an interesting day. You got the rules that we still have to break down, and I do want to connect with Todd sometime today. I'm telling him this live that I want to kind of walk through some of those rules with him. Be sure to get that story out as well, because December 12th is Tuesday. So we'll be tracking this very closely. Appreciate everybody tuning in again. Bishop on Air, like, subscribe, follow along. We've got plenty more to get to. All right, it's Bishop on Air right here on Twitter, Facebook, YouTube, wherever you can find it. Follow along.